What I have to you today is an interesting case about treaty override, when it's possible to do that, and anti-abuse laws. And the case is a Dutch case from 2016 dealing with deemed wages. But in order to understand the case, we need to understand what the law at the time said. So imagine you've got an individual holding more than 5% or more of the shares of a Dutch company. Then there is Article 12A of the Dutch wage tax law, which deals with deemed wages. And the article reads something like this. With regard to the employee who performs work for a body, so you need to work for the company, in which he has a substantial interest, i.e. you've got 5% or more, the wage earned in a calendar year is at least set at the maximum amount of premium income referred to in the Disability Insurance Act for self-employed, which is taken account at the most. So you need to take the maximum in that law, right? If it is plausible that in respect of similar employment relationships in economic traffic, in other words, in third-party relationships, a higher or a lower wage is customary, then you increase the wage to that based on that higher or lower wage. So you get a deemed salary if you don't give yourself a salary, right? And why would you not give yourself a salary? Because you don't want to pay tax. So if we look at an example, let's say your company has a turnover of 2 million and you've worked hard as director for the company realizing that turnover. You, however, decide that since the tax rates on wages are between 37 and 49.5%, you're not going to pay that. You're going to give yourself a dividend instead of, which is only taxed at 25%. So you give yourself a dividend for the money that you feel you need during the year of 200,000. Then what this law says is, it says, no, we will ignore the dividend and we will give you a deemed wage instead of 200,000 and tax that at 37 to 49.5%, which is obviously a lot more tax. This works fine in Dutch to Dutch relationships, but what happens, let's for instance say that the shareholder lives in Portugal, as was the case that we'll look at in a moment. Now what you find is if NLCO pays a dividend to its shareholder, the treaty says that NLCO can withhold 15%, but not more, and that the rest must be taxed in Portugal, or can be taxed in Portugal. That's the allocation, right? However, the Dutch national law says, no, but we're not going to treat that as a dividend. We're going to treat this as wages, and Article 15 says that we can tax the wages, right? Or if it's not Article 15, it'll be Article 16 for directors, where it doesn't always matter whether you actually are in the Netherlands or not. And the issue here is you're cheating your treaty partner out of income allocated to the treaty partner by requalifying what the income actually is. And the question is whether a good faith interpretation of the treaty allows that. Now, there's been some history to this case. This law came into existence in 1997, actually. But for the history, we need to be aware that there was a treaty between Belgium and the Netherlands in 1970 already. So what then happened was in 2003, the Dutch Supreme Court decided on a case between Holland and Belgium on this issue. And it said, you know, basically, the taxable years were before 2001. The deemed wages rule overrides the treaty and reallocates income, as we just discussed. This is not allowed under Article 3.2 of the treaty, which is the normal law that says if a term is not defined, such as income, in the treaty, then you need to look at the definition in national law, unless the context requires otherwise. And clearly the context requires otherwise here in the sense of good faith interpretation, because the treaty is from 1970 and there was no sign that Holland ever informed Belgium or checked with them whether they were okay with this one-sided reallocation of taxable income. Then in 2001, there was a new treaty between Holland and Belgium, and the treaty itself, the commentary to the treaty from both states, made very clear that Belgium was aware of the Dutch deemed with wages rule and that it affected the treaty and the income, the allocation of income under the treaty. So when there was a new tax case in 2013 between Belgium and the Netherlands, again for the same scenario where you had an individual living in Belgium and owning a company in Netherlands, the Supreme Court said the taxable years were post-2001. The deemed wages rule overrides the treaty and reallocates income. But this is allowed on Article 3.2 because Belgium was perfectly aware of what was going on, right? Then in 2015, there was a case before a local court, not the Dutch Supreme Court, between Holland and Poland. And the interesting thing here was the treaty was from 2008 and the deemed wages were levied so the treaty was from 2002, the deemed wages were levied in 2008. So quite clearly this was after the law was introduced, because the law was introduced in 1997 already, right? But here, the lower court said you cannot make the deemed wage assessment because it says there was no proof that the deemed wages rule was agreed to during a treaty negotiation or otherwise. They said, yes, the law existed, but we're not sure that Poland was aware of this law, and even if they were aware of this law, we're not sure that they understood exactly how it worked, right? And then you get the Dutch Supreme Court in 2016 deciding whether this local court had the right approach or not, yeah? A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. So let us see what the Advocate General says on unless the context otherwise requires. So we're talking about Article 3.2. It says any term not defined therein, in other words in the treaty, unless the context otherwise requires, have the meaning that it has at that time under the law of that state. So again, if the treaty doesn't define a term, you go to the law of the state, which is trying to apply the treaty, and you look at the meaning of that term in the law of that state, unless the context otherwise requires. And then the OECD commentary says, paragraph 2 specifies that a domestic law meaning of an undefined term applies only if the context does not require an alternative interpretation. And that begs the question, well, when does it require an alternative interpretation, right? And the commentary says the context is determined in particular by the intention of the contracting states when signing the convention, as well as the meaning given to the term in question in the legislation of the other contracting state, which is an implicit reference to the principle of reciprocity on which the convention is based. And this makes sense, right? I mean, if both states have in their national laws a funny but a similar interpretation of a particular term, it would be better than if one has a really weird interpretation and the other one simply does not have that. And the commentary goes as far as saying, as consequently the wording of paragraph 2 provides a satisfactory balance between the need to ensure the permanency of commitments when signing a convention, because you are committing to something, but it then says very crucially, a state should not be allowed to make a convention partially inoperative by amending afterwards in its domestic law the scope of the terms not defined in the convention. And the balance were right on with the permanency, but also the need to be able to apply the convention in a convenient and practical way over time. So you must use a dynamic approach, but it must be a restricted dynamic approach, right? So this is what the OECD model and the commentary says. Let's see what the Advocate General noted further. First, in the 2003 case, which he then quotes, the Belgian one we talked about before, I assume, which he then quotes in this opinion. He says Article 3.2 must be interpreted according to the Vienna Convention on the Law of Treaties, i.e. it must be interpreted in good faith within the treaty context and within the treaty object and purpose. And then this is an interesting point to make, which is not obvious, right? How do you interpret Article 3.2? I mean, Article 3.2 says you must look at the law, at the national law, but Article 3.2 itself must be interpreted as well, and that interpretation is ruled by the Vienna Convention on the Law of Treaties, right? And then in a conference, I assume, that was arranged in 2014. Apparently this happened once every several years. Avery Jones from the UK wrote in the Martin Ellis, which is a Dutch famous tax professor, graduation event on international tax law. The contextual interpretation, and this is freely translated by me from Dutch as I do not have the original document. The contextual interpretation only is necessary when an interpretation under national law must be rejected. So first, if you can apply international law, then you disregard the context that's referred to in Article 3.2, right? But if you do apply the context, then the word context in Article 3.2 has a wider meaning than the same word has in Article 31 of the Vienna Convention on Law of Treaties. And Article 31 of the Vienna Convention on Law of Treaties talks about how you interpret the treaty, and it talks about the primary means, one of them being the context of the treaty. I'll put the text below in the commentary to this video. Besides the meaning of context in Article 31 Vienna Convention on Law of Treaties, context in Article 3.2 of the OECD Model Convention includes the laws of the other state, again this reciprocity issue, and the tools of interpretation from Article 32 of the VCLT. In other words, the supplementary means of interpretation. So when you interpret Article 3.2 and you talk about context, context means that you need to look at the law of the state. You know, does the treaty require context to be different than the law of the state and of the other state, and of the primary means of interpretation under the Vienna Convention of the Law of Treaties, and of the supplementary means of interpretation of the treaty under the Vienna Convention on the Law of Treaties. I think these are interesting points made by the AG, so let's see what else he said. Now, after this, the Advocate General recommended that the Supreme Court disallows the deemed wages, and he gave the following reasons. He says, A, the application of the Deemed Wages Act changes the agreed treaty allocation, right, depending on the actual nature of the relevant income, because in the future this would have been dividends or gains, but always taxed in the resident state, which in this particular case was not Holland. 2, the extended protocol to the Portuguese treaty says nothing about deemed wages or an interpretation of the reward and obtained in Article 15-16, so of the treaty, right? So Portugal, nothing shows that Portugal was aware of the rule. There was no joint disclosure, right? Because the Advocate General compares this case to the Belgium case, where there was joint disclosure in the explanatory notes. The Dutch unilateral explanation says nothing about deemed wages or about national fiction. So when the Dutch submit a treaty to Parliament to be accepted and ratified, they give an explanation of what the treaty contains, and one might assume that maybe Portugal has got a translation of this, but it wouldn't have helped because it simply says nothing about deemed wages. The Portuguese treaty negotiators were not informed of the potential unilateral Dutch treaty allocation influence or of the risk of double taxation, so that Portugal can be deemed to have consented thereto is, as being legally relevant. So that was not the case. One cannot say that Portugal has agreed to this rule. It has not been argued that it follows from the Portuguese unilateral explanation that Portugal accepts the allocation of the deemed wages scheme. So that was another way that you could have looked to see whether Portugal was aware, and Portugal itself didn't have similar rules in force. Now this is an interesting one, because the assumption here is if two countries have the same kind of deemed fiction rules, which moves the allocation of income under the wording of the treaty, then they will be okay with it. It might be a fair conclusion, but it's also food for thought. And the Dutch Supreme Court then comes with a final decision. It says, a fiction in national law that reallocates income between treaty partners and is without equivalent in the law of the other state. Again, this thing of both laws have the same fiction, right? Can only do this if it is apparent from the drafting history of the treaty or other sources that the other state accepted that the national rule results in a different allocation of taxing powers from that provided for in the treaty. And then the court says the most important thing. It says, it should be noted that the fact that the other contracting state is aware of the existence of Dutch fictional provision is insufficient to assume that that state accepted the effect of this fiction in the application of the treaty. So you really need to not only say, by the way, we've got this law, you also have to explain the consequences of the law if you want to be able to say the other state should accept it. And therefore, the Dutch Supreme Court says the appeal succeeds and the taxpayer does not have to be taxed on this deemed wage income. That is all I have for you this week. I look forward to our next case next time. Bye for now.